This week, the Third Circuit handed down a decision which is a real humdinger in anybody's book. First and foremost, the opinion from the Third Circuit, called Henry Denby Peterson, entrenches a circuit split on an issue that is right now before the Supreme Court on a petition for certiorari. If the Supreme Court takes the case, as I suspect they will, the decision from the High Court will tell us something about the extent to which the automatic stay is really automatic. And in the cases at hand, the question is this: if a car has been repossessed before bankruptcy, must the lender automatically turn over the car after that person files a bankruptcy petition, or otherwise be held in contempt of the automatic stay? The Third Circuit takes the side of the minority and says no, the automatic stay is not automatic in that instance, and the creditor is not required to turn over the automobile until there is an adversary proceeding mounted in bankruptcy court and a turnover order is issued by the bankruptcy judge. And that is the second very important part of the decision, because the Third Circuit quite squarely holds that a motion for turnover is the improper procedure. In fact, the court says if all you do is to file a motion for turnover, you're going to be tossed out of court. Rather, the Third Circuit's decision by Circuit Judge Julio Fuentes tells us that instead the debtor must bring a turnover proceeding by an adversary proceeding, which means you must file a complaint, you must pay the filing fee, and then you need to either file a motion for summary judgment or a motion for a temporary or preliminary injunction. You've got to go through all of that before you can get your car back. If the decision goes the other way in the Supreme Court, well, then all you have to do is to write a letter to the lender, and they have to give the car back automatically. So this is a really big deal on two levels. First of all, if you file bankruptcy, do you get your property back automatically? And if you don't get it back, can you merely file a motion, which is relatively quick or inexpensive, or do you have to mount an adversary proceeding? Well, I don't think this is the last we have heard of this issue. Needless to say, as I said, I think the Supreme Court is going to grant certiorari and decide the automatic stay question. But on the other question about whether turnover can be brought by motion, well, on that subject, I think it's an issue on which the courts of appeal may disagree, and maybe eventually we will also get a Supreme Court decision on that subject. I am Bill Rochelle, the Editor-at-Large for American Bankruptcy Institute, and I will be back same time next week with something I hope just as interesting as what I've reported just now. Good day.